Hello, everyone. I'm going to take you through the thought of malicious prosecution. We're going to discuss the definition of malicious prosecution, as well as the different ingredients that need to be established before one can found action um, in the thought of malicious prosecution. Malicious prosecution occurs when one party has knowingly and with malicious intent initiated baseless litigation against the other party. Generally, you all know that criminal or civil cases should be filed when they have compelling evidence to support them. However, we also know that there are people that haphazardly initiate proceedings against others, well aware that there is no evidence to support those proceedings, and those actions are initiated for a different purpose other than that of bringing the alleged offender to justice. The motivation for bringing such action could be essentially to intimidate, harass, defame, or injure the other party in some way or the other. Such actions are referred to as malicious prosecution, as they are technically an abuse of court process, and that's why this thought is available. The thought of malicious prosecution essentially provides a check on potential abuse of court processes, and it's in place to discourage vexatious litigations. In order to succeed in malicious prosecution, the plaintiff must prove that there was a prosecution without reasonable or just cause, and that prosecution was initiated by malice, and that prosecution must have been resolved in the favor of the claimant. Unlike the other torts we looked at, like assault, battery, false imprisonment, in regard to malicious prosecution, it is necessary to prove that damage was suffered as a result of that prosecution. This damage is not only limited to pecuniary damage, which is money, but it could also be loss of reputation, or it could be emotional pain and distress. As I've already indicated, there are 5 ingredients that need to be present and established for one to found an action in malicious prosecution. The first ingredient is that there must have been a prosecution initiated by or with the support of the defendant. In the case of Martin versus Watson, it was stated that what is required here is for the defendant to have been actively instrumental in the instigation of the proceedings, and in the same case, the court guided that merely giving information to a police officer who then goes ahead to make an independent judgment on the matter, will not be sufficient to form the basis of a claim for malicious prosecution. So if I just go to the police station and report a case and move away, it may be too remote for one to initiate action in malicious prosecution against me. But if I go to the court and follow up the case and ensure that it is instituted in court, I liaise with the DPP, and I come to court to testify, and I'm in court through the hearing, it may be safe at that point to say that I've been actively instrumental in the instigation of proceedings against the claimant. The second element that needs to be established is that the prosecution must have been initiated without reasonable and probable cause. This particular ingredient depends on the circumstances of each case, and the test of a reasonable man is used to determine what could constitute reasonable and probable cause. I think that the whole aspect is whether a reasonable man in possession of all the facts would conclude that there was sufficient evidence to cause the police, for example, to think that the accused was probably guilty and should face trial. So it has to be demonstrated that there was a probable or justifiable cause for initiating that prosecution if a person is to get off the hook. But if it's clear that there was no reasonable or probable cause, then the claimant would succeed in proving that the prosecution was malicious. The third ingredient is that the proceedings must have been initiated by malice, and here the plaintiff has to demonstrate, as I've already said, that the proceedings were motivated by some other desire other than that of bringing the accused to justice. And here you can look at that case of Stevens versus Midland counties. The proceedings could have probably been filed for the sole purposes of intimidating, harassing, or defaming, or otherwise injuring the claimant, but evidence to that effect has to be adduced to court to demonstrate that the whole action was hinged upon malice. It didn't really have to make its way to court. There was no intention to seek the end of justice. It was just an action that was initiated probably to embarrass me or to intimidate me into submitting to something or generally harassing me. The fourth ingredient that needs to be established is that that case that was brought maliciously was actually resolved in the favor of the person now pursuing a claim under malicious prosecution. This means that the claimant must either have been acquitted, or the proceedings were dropped or discontinued by the Director of Public Prosecution or the prosecutor, or the conviction of the claimant was quashed on appeal. The only difficulty is that if a proceeding is quashed on appeal, it could, in a way, weaken ingredient 2 that relates to having a probable or justified cause, because you'll get the defendants arguing that, the fact that the court of first instance found it even fit to convict or decide against the claimant, it means that there must have been some probable or just cause, even if the case has now been quashed on appeal. So, well, but that depends on the circumstances of every case, of each case. The fifth and final ingredient that needs to be established is that the claimant suffered damages as a result of the prosecution complained of. And the damages, as I've already said, may not necessarily be pecuniary. It could be loss of reputation. It could be emotional pain and distress. It could be me being exposed to potential danger or damage to property or loss of business. Thank you very much for listening to me.